Welcome to The Explainer. Today, we're digging into a source document that details a really fascinating method for citizen advocacy. We're talking about a way to use a formal, sworn statement to hold public officials directly to their constitutional oath.
The material we're breaking down today proposes a very specific tool designed to do exactly that. The idea is to leverage some long-standing legal principles to create an official record. So let's see how this is all supposed to work.
Okay, to really get this method, we've got to start with the core document it all relies on, the affidavit. Now, this is way more than just a letter. It's a formal, sworn statement. At its heart, an affidavit is a statement of facts that you swear is true. Think of it as your testimony, but put down on paper and declared as truth under oath. The person making the statement, that's the affiant, and the person it's sent to is the respondent. That oath is what gives it its legal weight.
And these things are incredibly versatile. The source points out they're used for, well, all sorts of things, from settling local fights with the zoning board to formally documenting a rights violation or even disputing a decision made by a big federal commission.
Now, the specific method in our source document isn't just about any affidavit. According to the text, its power is drawn directly from the U.S. Constitution itself.
The source makes a really powerful distinction here. It kind of frames the original 1787 Constitution as the document that built the machine of government. But the Bill of Rights, which came along in 1791, that's presented as the user manual for citizens, and it was designed specifically to protect them from that very machine.
This whole process really hinges on a core principle from what's called the Supremacy Clause in the Constitution. It basically establishes that the Constitution is the absolute highest law of the land. That means no state or local rule can legally contradict it. This is the bedrock of the entire argument.
And here's the crucial part. This isn't just some abstract idea. The source really emphasizes that every single public official, from a local sheriff all the way up to a federal judge, takes a binding oath to support that supreme law. That oath is the very lever this affidavit process is trying to pull.
So how does a regular person actually plug into this system? Well, the source argues that this is where the First Amendment comes in. Sending a formal affidavit that lays out a grievance is positioned as a direct and powerful exercise of your right to petition the government. And this brings us to the legal engine that really drives this whole method. See, the source's argument isn't just about sending a statement. It's all about what happens, or more importantly, what doesn't happen next. It's about the supposed legal power of silence. The source hammers this point home again and again. The logic goes like this. When one person makes a sworn claim of fact, and the other person fails to challenge it with their own sworn counterclaim, the original statement is just left undisputed, and in the eyes of the law, it's therefore accepted as fact. This builds on a related idea, that silence can imply you agree. The source argues that in a formal back and forth like this, when a response is clearly required and you get nothing, that silence is legally interpreted as consent. And believe it or not, there's a specific legal term for this consequence. It's called estoppel by acquiescence. In plain English, it just means a person is legally estopped, or blocked, from denying a claim later on, precisely because their earlier silence was taken as their agreement. Now, to back all this up, the source document actually points to a few court precedents. Cases like Rena v. Geary and United States v. Tweel are cited as examples where courts have apparently recognized that silence, especially when you'd expect a response, can be legally seen as agreement or acquiescence. Okay, so we've got the legal foundation down. Now let's walk through the actual step-by-step process that the source material lays out. The source outlines a pretty clear 6-step procedure. It starts with you drafting that sworn statement and sending it by certified mail. That way you have proof they got it. Then you wait. If you don't get a point-by-point rebuttal back, the process escalates. First with a notice of fault to formally point out the lack of response, and then a notice of default, which basically declares the matter settled before you even start seeking a remedy. So what's the end game here? What does the source claim is the result of actually following this process to the end? What happens after that notice of default is sent? So once that affidavit goes unrebutted and a default is established, the source suggests you have a few ways you can go. You could try for an administrative fix, taking your now established facts up the respondent's chain of command. You could use it to create public pressure, or it could become the foundation for legal action, where that unrebutted affidavit serves as pre-established evidence.
So, when you boil it all down, the source presents this as a powerful strategy you can use outside of the courts. The whole goal is to create a formal record that stands as truth by default. It effectively shifts the burden of proof onto the official and creates leverage for a remedy, all without immediately having to step foot in a courtroom.
Ultimately, the method proposed in this source material leaves us with a really fundamental question. When does a citizen's sworn statement, met only with silence, actually become a tool for public accountability? It's a pretty provocative idea about the power of a documented, unrebutted claim in that balance of power between an individual and the state.